Hello viewers, welcome to another lesson. In today's lesson, I shall be taking you through English common law and Sierra Leone common law. This lesson is geared towards achieving two objectives. The first is for you to know the content of both regimes, and the second is for you to identify the differences and similarities between the two. English common law is defined as a body of principles developed from previous court decisions intended to be applied in subsequent cases sharing similar facts and issues with those previous court decisions. In other words, that a present case is decided by considering decisions earlier made by another court in a case sharing similar facts with the present case. Now, English common law has features. The first is that it is developed by reason of judicial decisions. In other words, it is developed by courts of law administered by judges. And secondly, if made by a superior court, it binds judges of all courts beneath it to apply it. But the reverse if made by a lower or equivalent court. In other words, this English common law works in an orderly manner of ascending or descending order. In other words, that there are those principles which are binding if made by a higher court and those which are persuasive if made by a lower court. Number three, it emerged from long established practice considered as unwritten law and resting for authority on long consent and usage, and this is referred to as custom. So it emerges from custom. Number four, some key ones have been reduced into writing, and these are referred to as casebooks. An example of such English law, English common law, is that of Hasbury's Laws of England, which contains principles of common law. Now, there are examples of common law principles. For instance, the area of contract. An example of such is offer and acceptance, and a case that is very pivotal in the on this principle of offer and acceptance is Gibson against Manchester City Council, and another is Torah against Manchester City Council. In the area of tort, duty of care principle was very pivotal in the case of Donaghy against Stevenson, and in criminal law, the burden of proof principle was very pivotal also in the case of Wilmington against DPP. Now, the Sierra Leone common law. The Sierra Leone common law is captured under Section 170, subsection 2 of the 1991 Constitution, and it is defined as the common law of Sierra Leone shall comprise the rules of law generally known as the common law, the rules of law generally known as the doctrines of equity, and the rules of customary law, including those determined by the Superior Court of Judicature. Now, this definition has components. The first is that the rules of law generally known as the common law, which has earlier been defined. The second is the rules of law generally known as the doctrines of equity, which will be discussed later. And third, the rules of customary law. Now, to the rules of law generally known as the doctrines of equity. This rule or doctrines of equity has been defined by legal scholars as a set of general principles which are said to govern the way in which equity operates, illustrating the qualities of equity. So, doctrines of equity has been defined in this way. Now, examples of doctrines or identified doctrines of equity by legal scholars are as follows. First, we have election, satisfaction. Thirdly, we have performance. And in the fourth place, we have conversion. So these are the four recognized doctrines of equity by legal scholars. Now, in this case, if Section 170, subsection 2 recognizes doctrines of equity, how about the other principles of equity, such as trust, mortgage, fraud, proprietary estoppel, or even the maxims of equity? Is it that Section 170 subsection 2 does not capture these principles? Now let's go back to Section 74 of the Court Act of 1965. Of course, it recognizes the doctrines of equity. So the same phrase, doctrines of equity, under Section 170 subsection 2 is the same that is captured under Section 74 of the Court Act, doctrines of equity. Now, though Section 170 and Section 74 provide doctrines of equity, the other rules or principles of equity have been also recognized in Sierra Leone through court decisions in Sierra Leonean cases, such as proprietary estoppel, fraud, mortgage, and even constructive trust. So these other principles of equity have been recognized also, even though doctrines of equity is used to describe equity in Sierra Leone as part of common law. Now, another segment of common law, Sierra Leone common law, is customary law. And customary law is defined as the rules of law which by custom are applicable to particular communities in Sierra Leone. In other words, it is specifically applied and not generally applied in Sierra Leone. Now, a detailed definition has been given by Section 1 of the Local Court Act of 2011. And this says that customary law means any rule other than the rule of general law, having the force of law in any chiefdom of the provinces whereby rights and correlative duties are acquired or imposed in conformity with natural justice and equity and not incompatible either directly or indirectly with any enactment applying to the provinces and includes any amendment of customary law made in accordance with the provisions of any enactment. So, in other words, customary law is that law other than general law. And general law are those other laws applicable or are enforced in Sierra Leone other than customary law. So, general laws are of general applicability, whereas customary law are of specific applicability to chiefdoms or particular communities in Sierra Leone. Now, what is the difference between English common law and Sierra Leone common law? In the first place, English common law recognizes rules of equity, whereas Sierra Leone common law uses the word doctrines to generally describe the rules of equity. Legal scholars, English legal scholars have provided specifically for doctrines of equity, and it's also part of the body of laws known as the body of rules known as equity, whereas Sierra Leone isolates equity on the caption doctrines. Now, Sierra Leone common law specifically recognizes customary law as a component of common law, whereas English common law is said to emerge to have developed from customs. In the fourth place, Sierra Leone common law still has those rules of specific community application, whereas English common law is of general application. In other words, that English common law has in present day no specific application, but it has general application in the whole of England, for example. Whereas in Sierra Leone customary law is not generally applied in the whole of Sierra Leone, but in specific communities. So, in conclusion, English common law has attained general applicability, whereas Sierra Leone common law has those parts of it that do not have general applicability but specific applicability. Thank you for listening. Thank you for watching. Please don't